Right. Hello and welcome to NDTV Profit. Today I'm joined by S Krishnan, Secretary of the Ministry of Electronics and IT. Sir, your ministry has been at the center of several sweeping reforms over the past year or so, right from online gaming to data protection, from AI to semiconductors. There's been a multitude of reforms that have come in that have shaped India's digital economy. So it's a fantastic time to be talking to you, sir. We caught up around the same time last year, and MeitY was buzzing then, and MeitY is buzzing now. So congratulations on a fabulous year. First things first, sir. The buzzword from MeitY that is coming out is the DPDP. When can we expect, sir, the final rules to come out? And what is the sort of all right, sir. Yeah.
No, on the DPDP rules, I think all the work that has to be done in MeitY has been done. We have taken on board. There were more than 7,000 independent inputs on the draft rules. So we took note of all of those, figured out what needed to be sort of cleaned up in the rules or what changes were needed. We've taken care of all of that. The changes are not very extensive over the draft, but it had to be carefully considered, which is why it took a little while. Mm-hmm. Now we've finished our part of the work. There is a process within government of a legal vetting which has to be done before it is finally issued. We are going through that process. So it's a matter of now fewer than days. I mean, it can be any time that it comes back to us for issue.
So, with respect to the DPDP, will there be a transition period that companies can expect?
I should say that the minister had set us a goal, saying by 28th of September the work should be done in MeitY. We beat that deadline, but we'll have to sort of.
So, with respect to DPDP itself, there were concerns coming in from the press itself. There were concerns from smaller players in terms of how they would be able to comply. Have those been put to rest very sufficiently?
They've more or less been put to rest. I think through the process of the consultations, we also had considerable awareness building about the rules. And I think most of the misgivings and misapprehensions have been addressed. So all of that has been taken care of, and I think as far as the media is concerned, they had also delegations from the media had also met us, and I think it was made adequately clear to them that the media is not seen as a data fiduciary. Okay. And also that most people who share data with the media do it on a voluntary basis, and that is with consent. So.
Right. Fair enough, sir. So another very important piece of legislation that has come out of MeitY is, of course, the Online Gaming Act now. What we can, in terms of now that the draft rules are out, it's open for feedback. What is the sort of flexibility that the MeitY has in terms of, let's say, in a situation where there are several concerns that are raised with respect to perhaps softening the rules in terms of the fines or in terms of the imprisonment terms? What is the sort of flexibility that the MeitY can afford?
I think as far as the main provisions in the main act are concerned, there is nothing that we can do now in the rules. Those are well considered provisions, and I do not think we have received any representations relating to the criminalization element or the fact that the penalties should be softened or any such. I think that has not been a request or demand that MeitY has seen so far. And in any case, that the rules cannot deal with. The rules basically deal far more with procedural matters and matters in the way that various parts of the implementation of the act is to be approached. So, and that is what it primarily deals with. And also the second bit that the rules deal with is that in the act, there's clarity on how an online money game is to be dealt with. But the Act also recognizes that there are other categories of games, online social games and esports. So there was a requirement for categorization of how that would be done. And that has been spelt out in the rules. How the categorization would be done, how the determination would be done, the process of the determination and the consequences of the determination. very important, in my view, provision of the rules, which makes it easier for online, the gaming industry itself to flourish, not the online money gaming industry, but the broader gaming industry to flourish, is that the rules do not require an obligatory registration of online social games. There could be a large number of social games, and we know what they are. They are recreational, they are educational, they are not involved, and they are positive outcomes. There's good content which is created there. That is a segment of the industry which the government is keen to promote, and that was very clear even in the act itself. So for that, the rules actually do not require online social games to necessarily register. That is basically an ease of doing business provision. So some new startup or a small venture which wants to set up an online social game, and it's not intended as a money game, they can go right ahead and do it without a registration. The registration of an online social game is voluntary, and the registration of an online e-sport, of course, is obligatory. But on an online social game, you don't necessarily have to register. Only if you want that there should be clarity that it is an online social game before it is being offered at large scale, you may choose to register it, and a determination is made. Of course, the authority will also have the power to actually look at online social games or any other online game which is being offered and examine whether it falls within the definition of an online social game or not, or whether it falls within the definition of an online money game. So that power is vested with the authority.
So once a platform is registered with the Online Gaming Authority of India, is that when they come under the purview, or without a registration, they still...
Without a registration, they can offer themselves. If they are sure that they are not an online money game, they can well offer themselves. I mean, somebody offering a game of Sudoku or a game of one of those, or a crossword game or something, I'm sure they can continue offering.
Voluntary registration for online games. Very interesting.
Online social games.
Online social games, right. So yet another, and the last of the legislations is the AI governance framework that is also expected. Again, it's said to be a broad-based sort of a framework, though there are separate already existing laws that govern parts of artificial intelligence within the country. What is the aim, and when can we expect some sort of a framework with regards to a comprehensive AI governance?
I think the framework is, again, the committee which is dealing with this has met, and there's just the final dotting of the I's and the crossing of the T's, which is currently going on. It should be out fairly quickly. But I think more important than anything else is that it defines the approach that India intends to take towards AI governance. And the basic idea is that do not regulate or legislate when it is premature or not necessary. In the AI space, we are fundamentally looking at ways by which innovation can be promoted, and we will regulate or legislate only when it is necessary. So which then means that if there are existing laws which are governing the space and which seem to be adequate to address the issues, we will use the existing laws in whichever way that we can to make sure that those issues are addressed. If there is a necessity to either clarify a provision or to strengthen a provision or to make some provision clear, that will be done. So whether it is the IT Act itself, whether it is the BNS, whether it is the Data Protection Act or the Copyright Act, all of those provisions would be used.
Right. So moving on to a bit of hardware now, that's also something that this ministry has really promoted. And we heard from the minister a couple of days back on the ECMS, the Electronics Component Manufacturing Scheme, highly oversubscribed scheme as well. What is the sort of foreign interest that you've seen in that particular scheme. Apart from MSMEs, right, 60% you've seen a lot of interest from MSMEs. What is the sort of foreign flow coming in?
Global companies also which have come in and they wanted to invest. We've seen a number of companies. There are Indian domestic companies, and there are, as you pointed out, MSMEs which are also domestic companies. So I think in terms of coverage, the coverage of the scheme has been wide. In terms of 249 companies distributed across the entire range of components that we wanted to address. So each of the sub-schemes has also been subscribed fairly in a fairly substantial way. In addition, the nature of the companies also includes a wide range. There are Indian companies looking to scale up, which was part of the intent of the scheme. There are foreign companies coming in to invest either directly or through in partnership with Indian companies, which address specific areas where we did not already have the technology or where production was not taking place, like SMD passives and some of these areas, laminates, flexible PCBs, and so on. So there are specific areas where that investment is coming in. Likewise, you see the component industry, because it involves, and especially things like capital goods and so on, and some of the module-based industries require other suppliers and vendors to come on board, and that is where MSMEs are playing a big role. So all of that is coming together quite well. So this is precisely what we were attempting to do, build the ecosystem. And the fact that there is a wide range of these companies and cross-section across the entire, whether you look at it by size or whether you look at it by sector, means that our goal is more or less in line to be achieved. The response that way has been extremely encouraging.
You mentioned about ecosystems. Another ecosystem that is being developed is the semiconductor ecosystem. And especially when we spoke on ISM 2.0, you said that it will be broader in terms of getting chemical suppliers, gas suppliers, other capital equipment manufacturers with regards to semiconductors as well. Could you give us some contour in terms of what we can expect from 2.0?
I think it has been made adequately clear, both when the Prime Minister spoke at Semicon and in various other speeches and statements made by the Minister. I think it's been made adequately clear that we will address broadly these elements. Number one, in the manufacture of semiconductors itself, there will be a focus on looking at a few more fabs for the country, fabs in terms of silicon CMOS fabs, in terms of compound semiconductor fabs, display fabs. So that is one priority area. Then within the packaging area, there will be a specific emphasis on advanced packaging. We will try to move up that value chain in terms of packaging. So that is in the manufacture part. The other very crucial part is the design-linked incentive scheme and how we can actually improve the design-linked incentive scheme to make it more attractive for people to actually scale up to a much bigger level. So this is basically fabless companies being encouraged to come up in India. It is a challenging environment for them also, but I think the scheme will be designed in such a way which will enable them to make investments, also possibly have access to risk capital so that they can grow. So, and it would be a very focused scheme. The earlier DLI scheme was very broad-based. We were trying a variety of things. Now, there'll be focus on specific sub-areas to see that we are able to move forward and deliver on actual products and actual systems that we can create out of the DLI scheme. So I think that will be an important dimension of what we will be attempting to do. And thereafter, there will be a focus, of course, as you pointed out, on the ecosystem players. Because as the manufacturing grows, then we need to bring in all the ecosystem players, because that is crucial to build up the resilience so that we are in a position to continue to operate in a resilient environment. And so each of this, and you would have seen in Semicon itself, in terms of the number of companies which participated, and their enthusiasm, you could actually see that the entire range of companies are keen to explore the Indian manufacturing scenario and see how they can actually establish base here. So I think that is another important forward step which we are working on currently, and it's a primary focus that we have.
Do you positively say that it'll be bigger than ISM 1.0?
See, I don't want to commit on the numbers and so on, because that's not my place to do. There is a process of consultation. There's a final approval by the cabinet. It's early to commit on the numbers. We have a level of ambition, and we will back it up, and hopefully, based on the resources available, we will get a size which is...
Right. Last couple of questions, sir. We've seen this growing wave, especially within MeitY, with Minister Ashwini Vaishnav also endorsing Zoho, moving on to Swadeshi Tech, the call for more and more indigenous products that are built in India. Will we see some sort of a policy focus also on enabling more domestic, large, these suite-based platforms?
See, I think we've always maintained, and this is there in the IT and software policy and so on. In fact, our earlier policy was itself called a software product policy. So I think we can't say it's some new thing we've discovered saying we want to do this. I think idea of developing software products and IT products in the country is something that MeitY has been supporting, and we are just intensifying the focus on that area. It is again part of the entire resilience framework that we are building to see that we are able to operate in a range, in a digital environment. See, I think what we need to understand about the digital environment is that initially it spread as something which all of us use. Convenience becomes the main factor, so a lot of it spreads. Today, it's the same environment which can also cause a lot of harm because it's so ubiquitous. And we've become so dependent on it that it is incumbent on the government to make sure that we have a resilient digital system in the country. And that means that we need to have certain capabilities, and we need to have certain products on which we can generate ourselves and which we can sort of put out there in the market, so that even if there's a disruption of any kind, we are able to manage, and we are able to be resilient and manage in that situation. So I think that is the key element of what we need to do, and that is the angle from which we look at this.
Lastly, sir, there is a very public legal battle that is going on between X and the government of India. X has called out Sahyog, which is the grievance redressal platform. They've gone on to say that it is not constitutional and several other things. What is the government's stance towards that issue?
The government has taken a very clear stance in the court. I think we have explained clearly that this is not a new procedure or a process. It is just a convenience platform. It is a convenience platform which was asked for by the Delhi High Court in a different case, and that has been provided. It is, you see, let us understand that the rule of law has not been flouted in any way. It is just that the existing provisions of Section 79, which provide a safe harbor and also provide for exceptions where the safe harbor from a social media intermediary can be taken away in certain circumstances. There's a process by which this taking away of the safe harbor from prosecution is being monitored, so that we have an idea of where it is being done, how much it's being done, and so on. So it's only let's be clear, only a convenience framework. It doesn't take away any of the rights. It doesn't take away any of the legal privileges that any entity has, anybody in the country has. It does not, in our view, transgress any of that. It just prescribes a process and a procedure and a platform to make it easier to monitor the entire thing. And thereafter, every intermediary has the right, because all that this platform will enable is a systematic way in which a notice is sent saying that there is so-and-so user who has violated an Indian law and he has posted something. We request you to take this down, or you're hereby put on notice saying that this is a violation of Indian law. If you continue to carry it, then you are abetting whatever is the crime that the other person has committed. This is all it means. And in any case, thereafter, if you are arraigned in the list of, in that particular case, in the list of respondents or so on, you have every right to defend yourself before the Indian courts. Where is that right taken away? So, I mean, it is the legal process is still available to you. So, I don't think that right has been taken away. And this has to be distinguished from Section 69A. In Section 69A, we actually order a blocking.
Okay.
And that is a unilateral government action where we tell a social media intermediary saying this content cannot be there, and we are going to block it. And sometimes they take it out themselves. Sometimes we actually block it through the telecom service providers and internet service providers. So that is a different power. That is government's own power. Therefore, we have a prescribed procedure we have to follow. We cannot just do it blindly. It has to show application of mind. I'm the first level authority which has to approve it as secretary in MeitY. I have to apply my mind to each case, and we do a diligent job. And the conditions under which that can be done are far more limited than even the conditions under which free speech can be restricted under Article 19, Clause 2 of the Constitution. So we, I think, have been very, very legally correct, and we have been process bound. The Karnataka High Court has given its decision. Of course, all the parties have a right to appeal, and we will continue to defend that this is a legally and constitutionally valid step that has been taken.
Thank you so much, Secretary Sir. Always a pleasure speaking to you. Viewers, this was S Krishnan, Secretary of the Ministry of Electronics and IT.